Get ready. Start. Sir, the position regarding extradition of fugitive criminals from this country was covered originally by three statutes, two of them of the British Parliament, the Extradition Act of England and the Fugitive Offenders Act of England, and the third, the Extradition Act of India, which has regulated the procedure governing extradition from this country. Both the Extradition Act and the Fugitive Offenders Act passed by the British Parliament became inapplicable after our independence because the first act applied to such territories as were notified as foreign territories by an order in council of the British Crown, and the second related to the British possessions and colonies. The Supreme Court held that the Fugitive Offenders Act did not any longer apply to this country. It was therefore felt absolutely necessary that a new law should be passed regulating the question of extradition of fugitive criminals from this country, and the matter was referred to the Law Commission. The government received a report from the Law Commission on the basis of which the present bill has been framed. The scheme follows mainly one pattern in substance, though in regard to the question of procedure for countries which are not Commonwealth countries and Commonwealth countries which are notified as such and as offering an arrangement for extradition of criminals with the government of India. The procedure is a little different, though again in substance it is the same. The whole question boiled down to certain fundamental principles which we have followed. First of all, we have defined in the second schedule extradition and offenses. That means that no treaty between the government of India and any foreign country or any Commonwealth country can include any offense which is not within the second schedule, but it can enter into a treaty with regard to some of these offenses, either all or some of them. With regard to Commonwealth countries, if the government of India come into an arrangement with any Commonwealth country and such an arrangement is notified and Chapter 3 is notified as being applicable to that country, then the procedure prescribed in Chapter 3 will apply to such a Commonwealth country. That means there is no automatic application of this act with regard to any foreign country or with regard to any Commonwealth country. There must be a prior notification applying in either case, chapter 3rd or other chapters in any case. Stop.